Hey, it's Jeremy West with Civitas Law Group reviewing the Lincoln Lawyer series on Netflix, episode 2.
You're due back in court in 41 minutes in Inglewood.
Inglewood.
But on the bright side, at least there's a file.
I know I harp on this. It's one of the things that makes law so dramatic on TV is that people find out that they've got to be in court in 24 hours or in 24 minutes, and they just go, oh, okay, I'm just going to make it happen. He just picked up a file for the first time. He's due back in court, and almost any time Hollywood insinuates that you're due in court, it's for trial. You'll be in court 1,000 times, not 1,000 times. Okay, I'm exaggerating. You'll be in court a lot, right? 5 or 6 times, maybe even 10 or 20 times before you actually go to trial in many situations. This guy's doing mostly criminal work, so the criminal stuff, yeah, you're going to have, okay, so here in Arizona, it's going to have an arraignment. He's going to have an initial pretrial conference. He's going to have a comprehensive pretrial conference, a final trial management conference, a trial setting, and then finally a trial. And that's if there's no continuances of any of those events, which usually there are at least a couple along the way. So 5 times before you get to trial, but usually more like 6 or 7 before you get to trial. He's due in court in 24 minutes, yeah, but it's probably not for trial, and he can probably get it continued. Because once again, this guy just inherited this law firm seemingly a couple of days ago.
You want me?
But I already paid Jerry.
And you already paid me.
Man, you a lawyer?
I am, and I'm busy with a client right now. You mind?
So that might look like, to most people, like just some Hollywood drama. It's really not. I used to go to court out at Mesa EDC. That's over at Mesa Superior Court, Maricopa Superior Court in Mesa. They don't have a whole lot of EDC cases there anymore. In fact, I think it's just juvenile out there now. But when it was out there, our in-custody clients would be all brought into one room. Just kind of picture like maybe the size of your average conference room. There are chairs lining the outside of the conference room, and you would just go sit right down next to your attorney, or your client would sit down next to the attorney, and you'd have to discuss the case. And you might have somebody sitting right next to you, another in-custody defendant that's talking to his attorney, and you're trying to kind of whisper and keep attorney-client confidentiality. A lot of times they don't even care, and they'll just talk out loud. But this guy that just comes walking up saying, hey, are you an attorney? Hey, kind of insinuating, can you help me out? I've had it. Yeah, that's happened to me. In that room, several times there were guys that were like, hey, what's your name? Do you know this guy? He's my attorney. I don't like him at all. Do you want to be my attorney? I don't find that to be a very professional thing to do, to just take their client, especially in that setting. So I've never once done it, but for that to happen, this guy just walking up or just grabbing your attention in a room full of in-custody clients, yep, had that happen.
Mr. Holler, that is your client's right, but I will have to give Mr. Choi time to prepare.
I understand, Your Honor, and he may need even more time once we introduce some evidence here. See, I noticed there was no body camera footage from Officer Granger.
Officer Granger's body camera was malfunctioning that day, Your Honor.
Right, if Officer Granger says so. Now, luckily, there's an ATM with a camera just across from where this alleged altercation occurred. Is there a monitor we can use?
Your Honor, the people welcome any footage Mr. Holler wishes to present. It will only serve...
The judge isn't going to want to see this. The judge isn't going to want to talk about evidence beforehand. The judge isn't going to want to talk about facts of the case beforehand. If we're there to talk about a plea, she's only going to want to talk about a plea. Is there going to be a plea, yes or no? If a plea is entered, she's going to want to go over it with the defendant. Essentially, he signed a contract. It's her job to make sure that he understands the contract he signed. But this whole, I'm going to introduce evidence right in front of everybody. Yep. Look, we love it because it's dramatic, right? But the way that that's actually going to go down is you're going to call the prosecutor and say, hey, I just found footage of the event and it's not what you think it is. I'm going to share it with you right now. You're going to email it over, and you're probably going to get the case dismissed. If it's, in fact, the bomb that, you really think it is, you're probably going to get the case dismissed without even having to go to court. The prosecutor doesn't want to go to court on a case that they think they're going to lose. And so if you drop a bomb and they look at it and go, that's not what we thought it was, they'll enter a motion to dismiss themselves.
What's happening?
Liars getting caught in their lies.
Okay, time served.
Only if you drop down to selling without a permit and expunge the whole thing from his record.
Fine.
Good news, Your Honor. I believe we've come to an agreement after all.
Okay, now I haven't seen this whole episode, but I'm thinking what they're trying to insinuate here is that there's not actually any evidence on that flash drive that Mr. Lincoln Lawyer here was just holding up. I think they're trying to make it sound like, yeah, he was just bluffing to get exactly what just happened to happen. Highly unethical. Does it happen? I don't know. I've never done anything like that. It's crazy because they can call you on it. The prosecutor it would just say, oh, well, Your Honor, we just need time to review whatever new evidence that Mr. Lincoln Lawyer here is presenting. Have a recess, they'd go out, they'd plug it into their laptop and go, yeah, there's nothing on this. Okay, we're going to trial. So not a gamble that you would want to take, especially since this is not how these situations actually go.
Your Honor, the people would not oppose a continuance. Frankly, we want to avoid Mr. Elliott claiming ineffective assistance because his lawyer was unprepared, especially given Mr. Holler's situation.
Now we finally get some realistic continuance language. Yeah, we don't want him to be able to claim ineffective assistance of counsel. In other words, they're saying later on he's going to file for some type of post-conviction relief or an appeal or something if you deny a continuance here. So we don't object to that at all. That's realistic.
Mr. Holler, the court is offering you a continuance. And clearly the people are in agreement. So?
Your Honor, under the circumstances, I'm afraid I have no choice.
No, I do not want a continuance, Your Honor. I don't want any delays. I'm sorry. I'm the one who's on trial here.
Mr. Elliott, in this session and in every session, you will allow your lawyer to speak for you unless I say otherwise.
Or you won't speak for yourself at all because you won't actually be in the judge's chambers. I've never once seen a situation where the defendant got called into the judge's chambers with counsel. If you're in chambers, it's because they don't want it to be in an open forum. They want to speak just to the attorneys. So I don't think he'd be in there at all. All right, and that is Lincoln Lawyer, episode 2. I'm looking forward to doing more reviews on this. I think we're going to keep going on this series. A lot of really interesting topics here and kind of packed full of a lot of lawyer stuff. So I'll see you next time.